Okay, hi everyone. Welcome to the 2024 Mid-Year Labor Law Update. Today is sponsored by the Alameda County Workforce Development Board. My name is Anna Manzano-Fairbairn. I'm the digital media and event strategist here at the California Employers Association. Before we officially get into today's content, I have just a couple housekeeping details for you. So as you see, your audio is going to be muted for today's presentation, but as you are already doing so in the chat, there's going to be lots of opportunities to engage during today's session. One of the main ways I know you're going to want to engage is by asking questions. So the best place to do that is going to be along the bottom. If you're on a desktop, you'll see two bubbles that says Q&A. That is going to be the best place because as one trainer is delivering the content, the other trainer will be managing the Q&A. I'll be over in the chat. And if you put a question in there, they'll either maybe see it, but I'm going to probably direct you to put it in the Q&A just so we make sure everything gets answered. Handouts for this training were sent out yesterday in the reminder email. However, I will also drop the PDF into the chat in just a minute. Once you see it pop up, you can just click it and it'll download locally to your drive so that you can follow along and have a reference of what we covered today. And then last but not least, we do have a survey. It takes about 60 to 90 seconds. It's only 5 questions, but the information that you provide to us, we share with our partners over at Alameda, and collectively, we just make sure that we're providing you with the best resources possible, especially trainings like these. So if you could take the minute at the end of today's training, you'll see a slide pop up. I'll also drop a link to the chat and would really appreciate you helping us out with that. So as I mentioned, today's training is sponsored by our partners over at Alameda County. Today we have Carmelo who's joining us. We're going to share more about the resources available to you as you see on the screen here, and he'll be available in the chat if you have any direct questions, and he'll put his information in there also. So now I have the privilege of introducing our trainers today. Today we have Mary Bradford and Eli Nunez, two of our amazing HR directors. And I know we got a lot to cover in today's session, so it's all yours, Mary.
Great, thank you so much, Anna, and welcome everyone. Really glad that you're able to join us. I'm going to do the first half of today's presentation, and then Eli will take over for the second half. But while I'm chatting, if you have any questions, please do use that Q&A box, and then Eli will be able to respond to you there. So let's go ahead and jump in to our mid-year labor law update. Well, the first thing we need to talk about is the amazing HR hotline that Alameda County Workforce Development Board provides to area businesses. So we do encourage you, give us a call anytime you have questions. 888-202-5668. That is the main number that you want to call in for the HR hotline. You are going to see on today's presentation that we have CEA's main 800 number listed on our slides, but this is the slide that you want to screenshot or jot that number down, and you want to give us a call on this number when you're calling in from Alameda County. And after today's presentation, if you think of something else you didn't have a chance to ask during the training, or if something else comes up later on, if it's wage and hour, leave of absence, employee relation issues, anything along those lines, we are happy to help you at the hotline. And that is provided no cost to you from the County Workforce Development Board. It's an amazing, nice benefit that they give you. So please make sure that you're using it and give us a call anytime you have questions. We're always happy to help you out. So if you're not as familiar with CEA, let me give you a quick intro. We are the organization that's behind the hotline. So we are the ones that are answering the calls when you call in on that hotline. And we're the California Employers Association. Our job is to try to make your life a little easier. So that's why we've got that hotline for you. That's why we have trainings just like this that the county provides for you, just to try to keep you up to date on the ever-changing California laws. And there are a lot, as Eli and I will be chatting about today, but we want to try to make your life a little easier and bring you that peace of mind. So we have that through the hotline. If for some reason you find that you need a little extra assistance, maybe you would like some on-site training, or you'd like some help putting together a handbook, we can also help you with that. Now that is above and beyond the hotline, but we do have individual memberships. If you feel that you need a little extra help, feel free to give us a call. I also want to point out our website to everyone. That is employers.org. We have all kinds of great tools and resources out there. Now, a lot of them are available for everyone to access. We have a lot of free resources, but some of them are behind a member portal. So keep in mind, some of the things that we talk about today are for CEA members. Another reason to think about a membership if you don't have one, but there's a lot of great resources out there. And I do encourage you to take a look at our blog. You can access all of our newsletters, and there's all sorts of HR stuff just to fill your day. If you don't have enough HR in your life, we're there for you. We're going to help you out. All right, our last legal disclaimer before we jump into today's material. Keep in mind that CEA is not a law firm. And even though Eli and I are going to be chatting about laws and Senate bills and all those kind of things, we are not attorneys. And so just like we're talking about today, when you call into the hotline, we're not giving you legal advice. You're not talking to an attorney and you're not getting a legal opinion. We're giving you a lot of information, a lot of options. Ultimately, any employment decision you make is up to you. So we're just here to provide you with as much information and resources as we can. But if you ever do have a matter of legal significance, we certainly recommend contact an attorney. Sometimes you just need to bounce some ideas or concerns off of an attorney. If you need help with an attorney, we do have a couple of great partners that are listed on our website. So take a look at that under our partner page if you do need some. And sometimes in California, you just do need to know an attorney. So keep that in mind. So here's what we're talking about today. I'm going to cover some wage and hour updates and just a couple of things to remember. Some of them might be a refresh for you, but keep in mind wage and hour is always changing in California. And it's changing July 1st for many businesses when it comes to minimum wages, specifically Alameda. So you want to be up to speed on that. I'm also going to tell you a little bit about workplace violence prevention and a new requirement you have coming July 1st. Then I'm going to turn it over to Eli. He's going to talk about some new rights for pregnant workers that everyone needs to know about. He's going to cover some industry specific rules. And then as we go through today, we're going to throw out a couple of frequently asked questions. We're going to throw out a couple of other reminders just to try to keep you in the loop here in the middle of the year. So let's start with wage and hour updates. And this is a lot of the times when we talk about some of these different laws, those are the things that you have to deal with at that moment. But wage and hour is an everyday thing that you have to keep dealing with and keeping tabs on. So let's kind of start back at the basics and just a reminder here about minimum wage in California. So as of right now, the state minimum wage for our non-exempt hourly employees is $16 an hour. So every employee in California has to be making at least $16 an hour. Now, we have a lot of cities that have higher rates. We'll talk about that in just a moment. But keep in mind, statewide, it's $16 an hour. You always have to pay employees at least minimum wage in California. Now, the reason why we want to pay attention to minimum wage is because that affects the exempt salary requirements. So right now, every exempt or salaried employee in California needs to make at least $66,560. So that is their annual salary. How they come up with that number is they take the state minimum wage, $16 an hour, they multiply that by 2, and then they multiply that by 2080, which is a number of working hours in a year. And that's how we get that $66,560. So it's important that you're paying attention to both of these because we always want to make sure our employees are classified correctly. So if you're thinking, gosh, I have an exempt employee and they're not making that much, or maybe you're thinking ahead to next year and think, gosh, salaries keep going up. I might have to adjust their salary and I can't pay them more than $65,560, or I can't get them to that next level. A lot of businesses, and I promise you will not be alone if you have to do this, have been changing their exempt employees to non-exempt. Yes, you are allowed to do that in California. That is perfectly fine. Because keep in mind, in California, employees automatically default to being a non-exempt hourly employee anyway, and it's up to the employer to show that they should be classified as an exempt employee. So when in doubt, you're always safer having them as a non-exempt employee. Also, it can make it a little easier to manage their time because you can clock their actual time because you're going to have them clock in and out to start and end their day, clock in and out from lunch. Sometimes if you're feeling like, gosh, we need to reduce hours or we're going to start working a modified schedule, due to a summer slowdown, or maybe business is slowing down in general, taking a look at changing your employees from exempt to non-exempt will give you a little more control over that. So since a lot of businesses are doing that, we have put together a really nice kind of a employee relationship how-to on transitioning your employees from exempt to non-exempt. So that is the bit.ly you see here on this slide. Take a look at that if that's something that you're going through, just to give you a couple of suggestions on how to make that process as painless as possible for everybody. Now, as I mentioned, we have a lot of cities that have their own local minimum wage. We have over 40 different local ordinances in California. Now, we're going to talk also about the fast food worker wage in a little bit, but keep in mind, different cities, different counties, different groups can have their own minimum wage. There's also some other things to consider, and you're in the Bay Area, so you probably know that there's also some predictive scheduling requirements, specifically in San Francisco, some flex time rules. Of course, we're all dealing with paid sick leave, although some cities have their own paid sick leave plans. What really is important to remember when we're talking about these different minimum wages and these different paid sick leave requirements is that you have to know where your employees are working, because where your employees are performing work is that local minimum wage as well as that paid sick leave that you really need to pay attention to. And why we're talking about this now, because in just a couple of weeks, it will already be July 1st, and we have a lot of cities that are doing increases in July 1st. Usually the state only does their increase January 1st, so that's kind of nice to keep a handle on. We have had a couple of cities that have started to go to April 1st increases, but then we also have all of these cities that are doing July 1st increases. And look at you, Alameda, city of Alameda, right there on the top of the list for Northern California. So as you can see, a lot of Bay Area cities have their own minimum wages, and then a lot of cities in Southern California also have minimum wage increases that are going up July 1st. Now, a couple of these cities are getting really close, or they are over $18 an hour, kind of getting a little closer to the new fast food minimum wage, which is $20 an hour, which again, we'll talk about that in a little bit. But kind of when you start to see these cities start to increase that minimum wage, that sometimes does start to roll over to statewide. So we'll probably still see some statewide increases for next year. The good news is statewide, we're still at 16, unless you are in one of those cities. And of course, make sure you pay attention to those cities. How in the world do you keep those all straight? Well, we've put together a summary sheet for you, and that is the bit.ly that is listed on this page. So make sure you can copy that bit.ly into your browser. That will bring up the increases. Keep in mind, that is listing the increases as of July 1st. So we have both out there that showed pre-July and then as of July 1st, but this specific bit.ly is showing you those July 1st increases, just so you can plan for any budgeting that you might need to take into consideration. So let's start to talk about some of these wage issues that you might come across. So here's a question we've got. Before an employee starts their day, we have them go through a security screen process. They have to scan their badges, they have to go through a bag check and a metal detector. The process takes 5 to 10 minutes each day because a line will form as everybody's starting their shifts at certain times. Employees then clock in to start. Is this okay? Well, probably not, because we have this really interesting case that came up this year, Huerta versus the CSI electrical contractors. And they gave us some really interesting things to consider. And another reminder that when employees engage in some sort of pre or post shift work, that probably needs to be on the clock. That is going to be compensable time. So just like when somebody starts their day and they need to get a bag check, when they end their day and you say, oh, wait, I can go clock out and then I'm going to check your bag before you leave the facility, chances are that needs to be compensable time. So let's talk about this specific Huerta example. So the employer had a security checkpoint where individuals had to enter and exit the work site. So this one area they had to come in. Each time an employee would come onto the premises, guards would have to scan their badge, and they would sometimes kind of do a vehicle check. So maybe they'd look into the vehicle, they would check for things, make sure everything was okay. A line would often form. It would sometimes take 10 to 30 minutes to get through this line. So quite a bit of waiting time for these individuals. Now, what happened is this time was off the clock. So employees were not being paid while they sat in line waiting to get through this security checkpoint. This ended up going to the California Supreme Court, and they said this time is compensable because it's considered hours work. Because again, the employer is requiring and supervising specific tasks. So again, that comes under that. The employer is, the employee is under the control of the employer. And when that happens, that's going to be paid time. That is compensable time. So as they were sitting there in this line, waiting to go through the security checkpoint that the employer was requiring, they should have been on the clock. So here's a couple of tips to learn from this lesson. Don't permit this pre and post shift work off the clock, such as security screens, logging onto computers, starting computers, that kind of thing. Sometimes it can take several minutes for computers to start up. If they have to go around turning on a lot of lights in a building before they're able to clock on, all of that time can add up. If they are donning or doffing, which basically means putting on or taking off any sort of protective gear, if they have to answer a couple of emails or they pick up the phone before they log in, setting alarms, cleaning up, all of those kind of things need to be paid time. So you might be saying, well, how am I going to pay the employees when they have to do those things in order to clock in? Well, this is where you want to take a look at your process. Maybe it does take them 5 minutes to unlock a door, turn on a couple of lights, and then they have to wait a few minutes as the computer warms up. And then finally, once the computer is on, then they can log in. Well, then you're going to take a look at where you need to add some extra time to their time card for that day because they were working for you. They were doing some things for you. Another option is maybe just take a look at a couple of other processes. Can a computer be left on but put in sleep mode? So it just kind of instantly wakes up as soon as that person comes on. Or could another employee who's maybe exempt, could they be responsible for starting up the computer and starting that process? So a couple of things to take a look at to make it work for your business. Then we had some other issues with this, which are really interesting with this case. After these employees went through the security check, they had to drive 15 minutes before they reached the parking lot. So it was quite a large facility that they were at. They said, well, hey, we're required to watch the speed limit. We have to drive over to this area. We have to comply with the guidelines. We should get paid. But the court said this time is not compensable because you're not really under the employer's control. You're just driving to a parking lot. So that in that situation, they didn't have to be on the clock. It was, again, just when they were truly under the employer's control, sitting in the line waiting to go through security, that they needed to be paid. Now, it also brought up a couple of other things, interestingly enough, on-duty meal periods. So in this particular situation, there was a CBA, which is a collective bargaining agreement in place, that said the employees had to remain on the premises for meal periods, but they were not paid. The court said, actually, they do have to be paid because they had to stay on duty for that meal period. In general, when there's a CBA, that can come up with their own rules and you follow the rules of the CBA. But in this situation, the court said, nope, even though the CBA said they didn't have to be paid, they do have to be paid. So what we wanted to share this with you is when we hear about these court cases, it does often influence other laws. So it's interesting to see how these will develop and if they will affect California. But the real lesson to take away from this is make sure that you are paying your employees when they are under your control. So thinking again about on-duty meal periods, keep in mind, very rarely does an on-duty meal period really apply for most businesses. Very limited circumstances. Maybe it's a job where somebody is working overnight. They're the only person working at a gas station, for example, and they simply can't be relieved and they have to be on duty. But what you want to make sure is that you have a written agreement in place and that both parties agree to it. And employees are able to say, no, I need to take a meal period, and you would need to accommodate. So you need to make sure you allow your employees to leave the premises when they need to. So specifically in general, for other employers, Always allow your employees to leave the premises for meal breaks and rest breaks. If you have a policy in your handbook that says employees cannot leave the premises on a rest break, you need to amend and update that policy. They are allowed to leave even for that 10-minute rest break. The other thing to keep in mind is if employees don't receive a meal break, or they don't receive a full 30 minutes for their meal break, or it starts late. Remember, meal breaks have to start before an employee has completed 4 hours and 59 minutes of work. If they don't get that meal period or it's shortened, they are owed what's known as premium pay, and that is 1 hour of pay at the employee's regular rate of pay. The other thing to keep in mind is now that premium payment needs to be on the wage statement that an employee receives, and it needs to be a line item that says this is a premium payment or missed meal period penalty, whatever you want to call it in your system. Just make sure that that is a separate line item in your pay stub so you can clearly show that you did pay the employee that 1 extra hour that they were owed. Now, the other thing to keep in mind is that premium payment is in addition to the pay that they received if they were working during that meal break. So they still get paid for having an on-duty meal period, and then they're still going to get that 1 hour premium payment. So got to make sure, work with your payroll company, that they are familiar with California laws and that they are paying the employees properly on those pay stubs as well. So let's transition over and start to talk about some health and safety updates that are going on in California. The big one you have probably heard about, workplace violence prevention plan, and heat illness is also something to keep in mind, very in the forefront here in California. I was down in the Bay Area last week, where it was actually quite toasty. Up here in the Sacramento area, we've already hit 100 a couple of times so far. So as usual, we sometimes have some really warm summers, and we have to keep that in mind for our employees. Well, let's start off by talking about workplace violence. As of July 1st, there are new requirements for the vast majority of businesses in California to implement and maintain a workplace violence prevention plan, or what's known as the WVPP. So yes, you read that correctly. That is July 1st, 2024, in case you are just hearing about this. There are some requirements of what you need to do as a business as you're setting up this workplace violence prevention plan. You need to get some employee engagement and get their feedback on concerns they have about the workplace, improvements they think could be done to make the workplace safer, training that they would like to see. So you need to give them an opportunity to present some feedback to you about workplace violence. You also are going to need to train your employees on your workplace violence prevention plan. That we're going to talk about training in just a second, but that is also supposed to be done by July 1st. So try not to panic. We have some great resources for you. We have a webinar coming up on the 20th. Eli is one of our amazing workplace violence prevention plan trainers. He will be doing that on the 20th. So I encourage you to sign up for that if you need some assistance with that. For those of you that are CEA members, we do have a workplace violence prevention plan toolkit that will really take you step by step through this process. Cal OSHA has also some great resources. Those are all linked in our toolkit. So we do have a lot of things available for you that you can use. So don't feel like we're just throwing this out at you, but you do want to add this to your to-do list. This is something you need to start to work on as soon as you possibly can so you can put it in place by July 1st. Now, there are a couple of exceptions to having a workplace violence prevention plan. What I can tell you is they're very, very narrow. So let's kind of take these one by one. If 100% of your workforce are teleworking employees and they do not come into an office, you are possibly exempt from a workplace violence prevention plan. If you are a business that has less than 10 employees at any given time and it is not accessible to the public, and you have an IIPP, you might be exempt from this requirement. But keep in mind, even if you're a small office, you have 5 employees that work in the office, for example, but you have 15 other employees that work remotely. If you get together 1 or 2 times during the year to have an all-staff meeting, then you have more than 10 employees in your office at any time. So then you would need to have a workplace violence prevention plan. So if you're a bigger business, even if you're a smaller business, but you have more than 10 employees that come into the work site at any time, you do need to have this. Sometimes we'll get questions from a coffee shop and they'll say, well, we only have 4 employees. We just work in the morning and we're just a coffee shop in the morning. Um, that's right, you're a smaller business, but you are accessible to the public. So then you do need to have a workplace violence prevention plan. So as you can see, most businesses really do need to have this. Now, healthcare facilities are exempt because they are covered by their own standard, as are the Department of Correction and Rehab, as well as law enforcement agencies. They have their own guidelines that they have to follow in regards to workplace violence. The vast majority of other businesses do need to have a plan. So you might be wondering, what are some examples, or what does that really mean when it comes to workplace violence? Well, this can be a lot of things, and it can actually kind of also go into the harassment area, which we'll talk about here. So an example of workplace violence could be a physical attack with or without a weapon. So that could mean if 2 employees get into a fight, maybe they punch each other, one person punches somebody else, maybe there is kicking or hair pulling or scratching or even spitting. That can be a type of physical attack. There can be the threat of physical force. If somebody says, I am going to beat you up in the parking lot after work, or I have a knife and I'm going to attack you, whatever it is, we have the threat of a physical force or the use of a weapon. And then we come down to this sexual assault or unwanted verbal or physical sexual conduct. Sounds a lot like harassment prevention, doesn't it? Yes, it does. So you might find that an employee makes a complaint about harassment in the workplace. Guess what? It might need to be part of your workplace violence prevention plan. It might be a recordable, something you're going to put on your violent incident log. And then you might have a situation where there is an animal attack. So my brother has a landscape company, and we were talking about this, and he said, well, I don't have to worry about animal attacks. And I said, really? I said, you've never had your crew out at a facility and there's never been a concern with an animal? And he said, oh, actually, we just started doing a big apartment project. And he said there was a dog that got off the leash and started running towards a couple of his guys that were doing some landscape. And luckily, no one was hurt. But I said, that's a perfect example. That's a dog. A dog can count as an animal attack. It could also be somebody that works in a vet facility or dog boarding or dog grooming. Or also, if you have delivery drivers, if your employees go out to drop something off at a customer's residence or at a customer's business and there is an animal there that attacks them, it doesn't just have to be dogs, then that could also be an example of workplace violence. So this is really one of those situations that it could be a lot of things that maybe you didn't necessarily think of as being violence, but if they are attacked against an employee, if there's some sort of physical harm, then it might fall under this. So a couple of questions that we get on workplace violence. What kind of training do I need to do? So as I mentioned before, you're going to work on developing your plan. You're going to start by getting some employee feedback. Then you're going to work on developing the plan, and then you need to train your employees. So what are the requirements of that? How long does it have to be? What specific topics do I need to cover? So let me give you kind of a rundown on this. The state, or Cal OSHA as of right now, has not specified how long the training needs to be. So it's really up to you. But what you want to make sure is whoever your trainer is, they do need to be knowledgeable about the content of your specific workplace violence prevention plan. That training also needs to be interactive. So employees need to be able to ask questions. They need to be able to find out where they can get some more information. They need to find out, how do I get a copy of our workplace violence prevention plan? Who do I report my concerns to? Or who do I report an incident to? So you're going to do kind of that initial survey of your employees where you ask them for feedback. But then if something comes up later on during the year, they want to be able to know where they can report that. Also, if you do have something that happens during the year, you might need to revise your workplace violence prevention plan, and you might need to do some new training if a new hazard comes about from the workplace. You also need to cover some specific definitions about workplace violence. There are 4 different types of workplace violence, and all of this will be covered in a lot of detail in our webinar coming up on the 20th. So again, I encourage you to sign up for that. But in addition to some of those definitions and making sure it's interactive, talking with the employees about the workplace violence plan specifics. You also want to talk about some of those hazards specific to the job. And so you might be a bakery, for example, you will have different hazards than an office environment might have. So you need to make sure you're talking about that. Also, the type of building that you have. Is there a parking garage with your building? Is there a stairwell with your building? All those different things that you need to talk about, let your employees know what those specifics are. I always like to say when it comes to workplace violence, I think it's really important that you make it very educational and informative. And it's really more of telling the employees things that they should know. For example, figuring out where all the emergency exits are and ensuring that your employees know where they are. You might be at the end of a really long hallway and all of a sudden you realize, I didn't know there was another stairwell over here, or I didn't realize that these windows opened and I could get out this way safely also. So a lot of this is really just training your employees and letting them know about any potential hazards and how to best deal with that. You also want to make sure when you're talking with your training, things that the business has done to correct any concerns there might have been. For example, employees might say, we have too many doors that anyone can enter in. Really simple. You put on a couple of keypads that only the employees have the key access to, or only employees can only go in certain entrances to the building. Maybe you need to restrict where employees can come in and out of in general. Sometimes we've been in buildings for a long time and we kind of don't think about any of those issues because we feel safe. But somebody might say, you know what, there was someone a little suspicious who was walking past the door and I heard them jiggle a door handle and it sounded like it was about to open. We need to make sure that that door is locked at all times or only accessible, kind of one of those one-way locks. You can only go out the door. So a couple of things that you just want to let your employees know. Again, it's just showing that you're being proactive. It's showing that you're following the guidelines that the state has set up, but also just reassuring employees that you're doing everything that you should do to keep everybody safe. The other thing you'll have to consider as part of your workplace violence plan is this violent incident log, and that's where these issues will be recorded. Employees will be able to have access to that, so anytime they say, can I see our violent incident log, you'll want to be prepared to show them that or let them know where they can access that if that's something that you keep on a server. So a lot of things to consider for that. So let's talk about some of the ongoing requirements for the workplace violence prevention plan. So we've talked about July 1 is the big day, but here's what you'll also need to make sure you do. You want to make sure you have an annual review of that violence prevention plan. So that means you'll need to come up with a team or a safety committee that will be responsible for reviewing it each year. And fantastic if you only have to review it once a year. But again, those would be the same people that would be involved if a new hazard is identified during the year so that you can be prepared to address that and revise that plan if necessary. You also annually need to solicit your employees' feedback on safety. Things change all the time. Maybe you move to a new building, then you're going to need to have a new workplace violence plan. Maybe something has occurred. Maybe your workforce has doubled, or maybe you've downsized. So again, every year you're going to want to make sure you're asking for that feedback. You will also need to do that annual employee training. So make sure you kind of set a reminder, July 1st, we should do a training every year. Keep in mind for employees hired during the year, you're going to want to make that workplace violence prevention plan part of their new hire orientation, just like you would do for harassment prevention, injury illness prevention plan, any of those other trainings you already do. So make sure that's just added into your training rotation. You also be a great idea when you've got your safety committee or your safety team set up, have them do periodic hazard inspections where they take a look, what has changed? Are things going on? Sometimes buildings will get built right next to you. Maybe we need to consider that could be a new potential thing that we have to think about if the escape routes has changed or your evacuation routes have changed. And then periodic safety meetings are always a good idea. Doesn't have to be a long drawn out thing. It could just be like, hey, let's take a look at our plan. Have there been any changes, anything that we need to revise or redo? And then that's really the best way to stay on top of that. As I mentioned before, we have this great DIY package. When it comes to your workplace violence prevention plan, that is something you can actually get on our store. You can order all the things I've talked about, even if you are not a CEA member. So there's a bit.ly to that. I would encourage you to take a look at that. And then, of course, you can always join us for a live webinar that's going to be next week, where we'll really get into that in a lot of detail. One of the last things I wanted to talk about before I turn it over to Eli is the indoor heat illness standard that's going to be coming here in California. So as you may already be aware, there is an outdoor heat illness standard and protections in place for employees that are working outside. But now they're talking about having an indoor heat illness standard, and this will probably be going to effect sooner than later. But what they're looking at are businesses or structures where in the interior it could get warmer than 82 degrees. So for most of you in just office buildings, you're probably just fine because you've got the AC that you can use. But if you're in another structure, maybe it's a warehouse that doesn't have AC, or there's a door that's open and the temperature just gets warmer and sometimes might go above 82 degrees. So Cal OSHA is planning on voting on this very soon, and they're going to have requirements that there are steps in place to protect employees. And again, it would be a heat illness prevention plan for that indoor consideration, where there could be cool down areas, where employees might need to have extra break time if they're becoming too warm, things that managers will need to be trained on in order to recognize some of those signs of indoor heat illness or kind of overheating, which we certainly know that's an issue here in California when it gets so toasty, things that you'll want to do if you do have to respond to an emergency situation, all of those kind of things. So that will be part of that. We'll get some more detail and we'll know when that goes into effect as soon as Cal OSHA votes on that. And remember, as I mentioned before, outdoor spaces already have that heat and illness plan requirement, where you have to make sure your employees do have all of those resources available. So indoor will probably be fairly similar to that. We do have a prevention toolkit for that outdoor heat illness that's available on the website for CEA members. So I encourage, again, take a look at that. Make sure you've got that up to date if you fall into that. And then just a couple of really quick other wage and hour things I wanted to remind everybody about. Well, you talked about how important it is to make sure your employees are always, of course, getting minimum wage. For our non-exempt employees, talked about time cards really briefly, but I do want to remind everyone, your non-exempt employees, you have to make sure they are clocking in to start their day, they clock out from lunch, they clock back in from lunch, and then they clock out at the end of the day. So for most of your employees, certainly those that are working full-time, you need to have 4 clock in, clock outs for each day that they are working. The other thing to keep in mind when it comes to meal periods, you cannot round meal periods. So for example, remember all employees, non-exempt employees need to have that minimum 30-minute meal period. If you have employees that are clocking in at 27, 28 minutes and your system automatically rounds them to 30 minutes, that is not allowed in California anymore. There was a big Home Depot case about that. So that is not allowed in California. They're also really scrutinizing rounding overall in California. So if your system is able to accurately record when your employees clock in or clock out to start or end their day, you should not be rounding in California. And really, we just don't recommend it at all. You are always much safer recording the actual start time and end time for your employees. And of course, for that meal period, as I said, make sure they're always getting a minimum 30 minutes. Just avoid rounding in general. It's really under a lot of scrutiny, and you just don't want to get caught on that, because then you're not going to be paying your employees correctly. If you're shorting them on time, you're going to owe them some wages. If you have an employee that goes to the DLSC, the Division of Labor Standards Enforcement, or the Labor Commissioner, you're looking at some really hefty fines. So be very, very cautious with that. All right, well, we have reached the midpoint, so I am going to stop sharing. I'm going to turn it over to Eli. Any questions or anything that we should clarify before we get to our second part?
Thank you, Mary. The big one I think was as far as the training requirement for that workplace violence prevention. And yes, the question came up a couple of times. Yes, the deadline for that is the July 1st, the same day as you're supposed to have that plan in place. So not only do you have to have your plan done, but you have to have everybody trained. So, make sure that you're not violently, furiously typing away on June 30th trying to get that plan together because you still have to get everybody trained on it and get that feedback and everything. So this really is,
Maybe
quite the
you're
requirement. And, anything we can do to help on that, of course, give us a call and see if you have any questions on it because, while I don't know if OSHA will be knocking on your door on July 1st asking for your plan, I mean, you don't want to be caught in that position. Let's just put it that way.
right.
That's the biggie. So, well, that was it, I think. Thank you, Mary. Thanks for all the great information. I'll go ahead and take over here. Go do some more info, and as always, you have any questions, just throw them in the Q&A. Mary is, believe me, more than able to answer any of those questions or let us know if there is anything we need to do with that. So, I'd like to start the second half talking about some employee rights and protections. And really, we have a new regulation that came from the EEOC regarding pregnant workers in the workplace. So we'll go ahead and start with that one. This is basically what is the Pregnant Workers Fairness Act, and this is going to apply to all employers with 15 or more employees. And this is basically the if any of these things sound familiar, it's because they kind of modeled it after the Americans with Disabilities Act. And what it does is it's a requirement for employers to engage in an interactive process and reasonably accommodate any limitations related to pregnancy, childbirth, or related medical conditions unless it creates an undue hardship. So this passed in June of last year, and it becomes effective in 5 days. 5 days from now, June 18th, 2024 is when this goes into place. So hopefully, your workplace is got some measures in place already and is familiar with the California regulations and protections for pregnant employees because that'll go a long way in helping with this as well. Thing to keep in mind is that this goes beyond the Americans with Disabilities Act because of the requirement for limitations or for accommodating limitations that are related to pregnancy, childbirth, or related medical conditions. So, in other words, I mean, with the ADA, basically, if any of you haven't ever been involved in the interactive process, you know that you can request any kind of documentation, doctor's notes, that sort of thing, that basically tells you what the limitations are. Well, in this case, we're looking at any kind of limitations or issues that could be related to childbirth. So, for instance, if we're talking about things like morning sickness, migraines, or even attending prenatal appointments, those can all be covered and protected by the Pregnant Workers Fairness Act, which, it's I think it's a long time coming, but of course, that it's also going to cause some headaches for some employees, right? One more thing to accommodate or deal with. So some other things that are included with this, things that are related to pregnancy or to childbirth. So things like breastfeeding or pumping milk, use of contraception, menstruation, fertility treatments, that sort of thing. Or even some protections for birth control or reproductive decision making. Some of these things may also be covered as well. So, keep in mind again, this came from the federal government. There's a federal act under the EEOC that is rolling out and is going to affect quite a few employers. Like I said, anybody with 15 or more employees falls under these protections. So you may be asking yourself, well, we've been to your webinars before, and you've talked about California's protections, the Pregnancy Disability Act, and that sort of thing. So, just to revisit those, a review of them, California law, the Pregnancy Disability Act, some other acts already has protection for any employees where there are five or more employees, right? Any employers where there are five or more employees, I mean. So basically, what California requires is that employers reasonably accommodate employees that are either disabled or affected by pregnancy. And this is certified by their healthcare provider. In other words, you have an employee that reports to you that they're pregnant, that their doctor needs to take them off at work for a few weeks before the birth date or what have you. So they provide you a doctor's note, or you ask for a doctor's note explaining that limitation, whether it's time away from work, whether it's that they, can't do a certain aspect of their job or need extra breaks or what have you. They provide you some kind of documentation from their medical provider. And medical provider, of course, is defined by California as well. That could be their doctor, OBGYN, it could be their, licensed midwife or that sort of thing. So basically any certified healthcare provider can give you that information. And what California's protections provide is up to 4 months or 17.3 weeks is what it translates into of pregnancy disability leave. And again, this is a certified by the healthcare provider. Now this 17.3 weeks or these 4 months do not have to be taken all at once. It can be broken up as the medical provider sees fit. So in other words, if the medical provider determines that, hey, this person has, this condition associated with pregnancy, say high blood pressure or morning sickness or what have you, and there could be 1 or 2 days a week that they need to miss, or they have to come in for a treatment related to their pregnancy or something, so they have to miss this time, then that person can take that just those small fractions of the week away or a fraction of the day or what have you as as directed by their doctor. So again, doesn't have to be the 4 months all at once. It can be broken up as needed. And of course, these protections for employees means that they won't be harassed, discriminated, or retaliated against for their condition. In other words, we were having this discussion offline before the webinar started about employers that I used to be, if somebody was pregnant, couldn't perform their job, they just show them the door, right? Move them right out of the workplace, which of course, is obvious discrimination for pregnancy. So again, you know, any harassment, discrimination, or retaliation against a pregnant employee due to their pregnancy or any associated condition is illegal and protected by the state of California. Now, having said that, you may be asking yourself, does the Pregnant Workers Fairness Act set up by the federal government, does that have any impact on California employers? And that's a question that, we've gotten a couple times, and even the question we asked ourselves when it first came out, because as we know, being either California natives, California employers, California residents, however you want to put it, we know that typically California tends to provide more protections than the federal government does, especially when it comes to employees, right? For things like harassment, there's certain things that the federal government tells we have to do, and then California goes beyond that. Same thing with safety protections. That's why you have, your federal OSHA department, then you have Cal OSHA that tends to be more stringent or more strict than the federal agency. So in this case, does the Pregnant Worker Fairness Act impact any California employers, or is it basically just rehashing, what California already said? Well, in this case, and you may want to mark this on your calendar as the day it happened, because it doesn't happen very often. But in this case, yes, actually, the EEOC ruling is actually more protective than what is out there for California employees already. It actually goes beyond what California is asking employers to do. And as you may know, if there is a law out there and something comes out that's more protective, you have to go with the more protective one, right? You have to go with the one that provides more protection or more benefit for your employees. So in this case, for instance, I mean, for those of you with 15 or more employees, this new regulation basically says that you could temporarily suspend essential job functions. So I'll give you an example, for instance. Under California protections, if somebody couldn't perform the essential functions of the job, maybe they'd go on leave of absence. It'd be a protective leave, but they go on leave of absence. In this case, under federal law, though, you can temporarily suspend some of those essential job functions. In other words, take those duties away from them so they can continue to work or perform other aspects of their job. It also mandates that we have to provide certain predictable assessments. In other words, certain things that are commonly associated, if you will, with pregnancy or pregnant employees. So in other words, carrying water with them, maybe additional breaks, whether it's for eating, restroom breaks, or just resting, right? Maybe give them a job or the ability to sit when standing is required or stand when sitting is required. Basically, any modification that is necessary that is commonly associated with pregnancy is something that employers should do based on this new regulation. And here comes the tricky part for you. there are certain instances. So in other words, if something's fairly predictable, in other words, extra bathroom breaks, extra breaks, the ability to sit down, that sort of thing. If it's predictable or common knowledge, if you will, common practice, then it is not necessary to request medical certification for that. In other words, if your employee comes up to you and tells you, hey, you know what? I'm, 4 months pregnant and, I need to go to the bathroom more often. I need to take extra bathroom breaks, that sort of thing. And my supervisor is hassling me about it. You need to step in right away and put a stop to that hassling because, again, the need to go to the restroom more often, that sort of thing, that's something that's usually commonly associated with pregnancy. So, again, that is something that would be protected under this new EEOC regulation that goes beyond what California had in place. So, again, don't just think that just because there's a federal change that California already has something in place. This is one of those cases where it is actually more protective than what we already had in the state. So keep that in mind. And I'll give you an example too. So in this case, we have an employee named Erica who's pregnant. She presented a doctor's note that certified that she can no longer lift for the remainder of her pregnancy. However, lifting is an essential function of her job. How do we respond? So you see from the picture, we have maybe a warehouse environment or, a loading dock or that sort of thing, where Erica's job is to lift boxes, move boxes, that sort of thing. But her doctor said she can't do that anymore. So what do we do? Well, typically, what we would do in California, if you have 5 or more employees, is, this person cannot perform an essential job function, leave of absence, right? However, according to the EEOC, if that pregnant employee is not able to perform that essential job duty or job function temporarily, then you have to look at other alternatives. So in other words, you may have to offer a light duty or an alternative job, maybe change work assignments, or move them to another department or what have you that they're able to do for up to 40 weeks. That is a long time, of course. Now, and again, you may not have the capacity or the ability to change them, right? You may say to yourself, well, that's really, it doesn't work for me. It's an undue hardship. What can I do? Well, that's difficult as well because as you may know, or if we've talked to us before, we tell you that undue hardship, that is up to the employer to prove that it is a hardship for them. And really that burden to prove that is really high. And as Mary's mentioned before, I mean, there are some very narrow exceptions to things. This is one of those, right? So what I recommend to you is if you find yourself in the position where, you have a pregnant employee that's looking for a modification, a change of job functions, that sort of thing, and you think that you really cannot do it, it's undue hardship, you want to fight it, you really cannot do that at all, that is one of those instances where you may be better off contacting legal counsel if you really want to go that route. I mean, it's again, that undue hardship, it's going to be up to you as an employer to prove that it goes beyond anything that you can do. And it's definitely, harmful for you as an employer to try to accommodate that. So, take a look at that. And again, if you think that you have to go that route, you know, contact your legal counsel. And again, what this modification does is instead of, when an employee comes to you and says, hey, I can't perform my job, the doctor says I can't lift or I can't do this or I can't do that, instead of just automatically going to put that person on leave, we may be required to go through that process where we try to find another assignment, light duty, something else for them to do. As I mentioned the first slide too, this change does have a effect on lactation protections in the state of California. And there's been some changes there as well. So, I mean, California already has some pretty extensive protections for lactation accommodations. And if you're a member of CA, we've done a little work on that, little research. We have a notice that you can use and forms that employees can use to request that protection. And there was some more work done on this by the federal government back in 2022 with what they call the Pump Act. So just as a recap, basically what this protection state is that if employee needs time um, for lactation to express milk or for lactation functions in the workplace, you have to provide them a place to do it. It can't be the bathroom. It's got to be a clean place. It has to be in proximity to a refrigerator where they can store it. there has to be an electrical outlet there for them to connect the pump, that sort of thing, right? So you have to make an accommodation, designate a place for them to be able to express milk. That's part of the lactation protections. In addition, they can do it during their scheduled break times, or they can do it, take additional time away to do it as necessary. In other words, if they have two 10-minute breaks and a 30-minute meal break, they could do it during that time. But if they need additional time to do it, they can take that time away from work to do it. But however, that if it's not coordinated with regular breaks, that time can be unpaid. So in other words, if they need additional breaks for lactation beyond their 10-minute break, you can ask them to clock out in order to do it. Now, so what's changes now? Well, this new regulation basically expands on what a lactation accommodation is. So this expansion means that now employees are permitted to take the time to actually nurse their child during work hours if the child is in what is considered close proximity to the employee. So in other words, if you have a remote employee that's nursing, they can actually take that time away from their remote work, from their computer, whatever it is, if their child is nearby. Maybe their child's in another room being watched by a nanny or a relative or what have you. They could take time away to nurse that child. Same thing if you're in a location that maybe has a daycare on site, the employee may be able to take time away to nurse their child during the day. Or if there's a daycare, if the daycare is really nearby to your workplace, maybe the employee can take time away to do that as well. So again, it basically expands the definition of lactation, if you will, or the protections there to include nursing the child in person, I guess, for lack of a better word or better way to put it. So keep that in mind. This basically is an expansion of those rights, and hopefully you're already, doing those accommodations for lactation for your employees. If it hadn't crossed your mind, or you're in a situation where you hadn't thought about it, or you don't have a private place for employees to do that, maybe take a look around your workplace, around your office, and start thinking about designating a place or an office or what have you for employees to do that. Again, just a reminder, you can't, designate the employee that they have to do it in the bathroom or anything like that. It's got to be a designated private area with electrical outlet, lights, obviously, and it's got to be in close proximity to a refrigerator or refrigeration unit for them to store the milk. Now, hopefully that lactation notice, those lactation protections, you're giving it to your employees on their first day to work and posting them. And one thing I always tell callers and our members is if you're giving employees information on, workers' compensation, lactation, CFRA, whatever it is, give all employees the same information. Don't make assumptions that, oh, well, I'm hiring this male employee, so he doesn't need to know about lactation, right? Don't make those assumptions. Just kind of make sure that you're just giving the information to everybody. It's a good insurance. Now, question came up, as far as what is considered close proximity for lactation. Um, and as you would expect, they're pretty vague on that, unfortunately. So, um, I guess close proximity would be considered something that maybe the employee can do during their assigned break. So, in other words, if you have the daycare facility that is right next door and the employee can walk or drive over there and maybe take an additional 10 minutes on their break, that may be considered reasonable. I don't think they've given us an actual number as to say, it's got to be within a certain number of miles or a certain number of time. Um, if you consider something that if they have to drive 30 minutes away, 30 minutes one way, 30 minutes the other, that is more than likely not considered reasonable. So basically, I'd say something where if it's walking distance, if it's something that could be performed within the 10-minute break or maybe a little bit beyond that, that could be something you need to accommodate. Anything where you're looking that they're going to be away from the workplace for an hour or so, that probably goes beyond what is considered close proximity. So again, good rule of thumb is just to think, can they do it or almost do it all during their break time? That would be considered close proximity. Once you go anything beyond that, you can, take a little more careful look at it to see if it's something that would qualify under that protection. All right, let's move to a couple more rights and protections and more changes that have taken place recently. We'll talk about non-competes, some changes to harassment prevention, something, one of our favorite subjects, of course, and I know some of everybody's favorite topics. So let's talk about some of these protections and how they've changed in the past year, how they're looking to change possibly in the future. Before we jump into that, though, I'd like to talk more about paid sick leave. And you may be telling yourself, well, why is Eli talking about this? This has been in place for years. This has been in place as long as I've been in the workforce, right? Well, reason we want to remind people of this is because we still get several questions on it. And honestly, because it changes all the time, or it changes fairly, recently. And I mean, most best example of this is the change that took place at the beginning of this year based on Senate Bill 699. What that did was it increased the amount of paid sick leave that employees are getting from 3 days or 24 hours up to 5 days or 40 hours a year. So hopefully you're not still doing the 3 days or 24 hours. Hopefully you were aware of it. Hopefully you saw our blogs and our notices and attended our labor law updates last year and you changed the amount to 5 days or 40 hours per year. Now the question comes up quite often is like 5 days or 40 hours, isn't that the same thing? Not necessarily. So it is either 5 days or 40 hours per year, whichever is more. What do you mean by that? Well, what I mean by that is if your employees are on an alternative work schedule where they work 4 10-hour days, then technically they should get 5 days of paid sick leave. So instead of awarding them 40 hours for the year, since they work 10-hour days, you would be giving them 50 hours for the year. Because in that case, the 5 days, the 5 regular work days for them is actually more than the 40 hours per year. So again, that just, jumps out if you work on alternative work schedule where you work, 4 10s or a 980 or 312s or whatever it is, keep that in mind that you may have to go beyond the 40 hours per year. As far as how you award that paid sick leave, you can still use either the lump sum method or the accrual method. Both are still perfectly fine to use as long as you use the right amount, of course. With the lump sum method, there is no carryover. In other words, if you give everybody, 40 hours or 5 days of paid sick leave on the first day of the year, and it gets to December 31st and you have employees that have not used any of it or have only used 1 or 2 days and they still have some in their bank, you can zero it out before you award them the full 5 days or 40 hours the first of the next year. There's no need to carry over, no need to carry a bank because they're not really starting from zero if you zero it out, right? Because you're the very next day you're awarding them their full allotment for the year. So again, no carryover in that case. However, if you use the accrual method, where you're awarding at least 1 hour of paid sick leave for every 30 hours worked, then you can actually, you know, you have to carry that time over. And surprise, surprise, the cap on how much can be accrued was increased as well. Because the old cap was based on the old 3 days and 24 hours. You double 24 hours, you cap it at 48. Well, guess what? Since the amount awarded each year increased, the cap has to increase as well. So the cap for the accrual method increased to 80 hours or 10 days. Again, whichever is more. So keep that in mind. If you have a system set up or your payroll system automatically accrues paid sick leave and, you just change the accrual, make sure you change the cap on there as well so that you're not capping them too low. And again, we're for the accrual method, we're still using that 1 hour for every 30 hours worked. And that's all hours worked. For some other calculations, for other things, we don't use overtime, but for paid sick leave, we do have to include overtime as part of the hours worked. So you're saying, well, why are we spending so much time on paid sick leave? We're aware of it, it's been around for years. Well, reason for that is because paid sick leave is still one of those things that gets employers in trouble, either denying paid sick leave or not awarding it correctly, not showing it on the pay stub, that sort of thing. That is one of those things that's really low-hanging fruit for litigators, you know for disgruntled employees and that sort of thing. So some ways to avoid getting in trouble or to stay out of trouble in this field is make sure that your wage statements or another document that you provide on payday shows the sick leave that is available for use. So in some cases, for instance, if you use the accrual method, the employees may have more paid sick leave in their bank that they're allowed to use for a year. Remember, you have to allow them to use 5 days or 40 hours per year, but if they rolled some over, it can go beyond that. So in those cases, you want to show maybe how much you have available and how much you have available for use. But whatever it is, just make sure you have that information available either on their wage statement or on a separate document that you provide them. Some people ask, well, can we just post it online? Can we just make it so they can access their payroll system to do it? If you're going to go that route, we always say make sure that you're giving the time to do it at work, that you provide a computer for them to do it on, that you provide them the ability to print without any kind of cost to them, similar to a pay stub if it's a digital. So it could just be easier for you just to put it on the wage statement, honestly. Second point on here is training your managers and your supervisors, basically foreman, whatever it is. Basically, anybody that's going to have any say or be affected by absence or paid sick leave, make sure you're providing them training on it as to what the rights of the employees are and what they can and cannot do as managers. Because sometimes if you have a manager or supervisor that's frustrated because somebody's always calling in sick and they have the sick time available, guess what? If they try to discipline that employee or try to, not pay them for a holiday or deny them paid sick leave and it's available, that could definitely get you in trouble. So again, make sure you're training your supervisors, training your managers, training your frontline supervisors, right? As to the employee rights and their responsibilities when it comes to paid sick leave. And really, I mean, train those frontline managers on anything that could but come back and affect you because a lot of times when we see businesses get in trouble, it's not always the business owner making those bad decisions or making those incorrect decisions, right? Sometimes it's things that those frontline managers or supervisors do or don't know about that can cause you in trouble. Now, if you have a PTO policy that encompasses both vacation and paid sick leave into one bucket, make sure that it is compliant. And what I mean by that is, the way I like to put it is if you have a PTO policy that has both paid sick leave and vacation all clumped up into one bank, all the protections of paid sick leave apply and all the protections of vacation apply. So in other words, typically if an employee leaves or is terminated, you don't have to pay out their sick time. However, if it's all combined into one PTO bank, you do have to pay that out because that's a vacation protection. And at the same time, you also cannot count some of those absences that are used for paid sick leave purposes against them if they have the time available in their bank. So if you have a PTO policy in place or if you're thinking of switching to a PTO policy instead of having separate banks, give us a call. Give us a call at the 800 number, or if you're a member, give us a call on the hotline to talk about it so we can talk about the pros and cons and maybe talk through it with you, see, some things to avoid. Other things to keep in mind, again, if you have a different accrual method other than the 1 hour for every 30 hours worked, you have to make sure that the employee has at least 24 hours of accrued sick leave by the 120th calendar day of hire. So in other words, if you say, well, instead of doing 1 hour for every 30 hours worked, I'm gonna, accrue it for how many days they work or how many weeks they work or whatever. If that's the case, you have to make sure that that employee accrues 24 hours by the 120th day of employment and 40 hours by the 200th calendar day of employment. So in other words, if that employee is sick or absent for a week or 2 weeks, you can't just not let them accrue because you may fall below that accrual threshold. So saying, well, that's kind of confusing. What's the easy way to get around it? The easy way to get around it is to just make sure that you're doing the 1 hour for every 30 hours worked accrual. And as long as you're accruing at that rate, then you are compliant. You say, well, what if the employee doesn't hit those 24 hours by the 120th calendar day because they're absent or whatever? If they're still accruing 1 hour for every 30 hours worked, you're compliant. That is the easiest way I can tell you. The easiest, safest way to stay out of trouble is just follow either the lump sum method or the 1 hour for every 30 hours worked method. I think we've kicked that around quite a bit, but if you have any questions about paid sick leave, give us a call. Let's talk about non-compete agreements, though. We have Senate Bill 699 again. You may have heard about this one. Basically, California was already pretty unfriendly towards non-compete agreements. So what SB 699 did was it expanded that. And what I mean it expanded, it didn't just expand protections, it expanded these protections to a point beyond California's borders. So in other words, what that means is that no matter where the employee signs that contract, that non-compete agreement, if they come to work for a California or in California, that non-compete agreement cannot be enforced against them. So if you have an employee that works at a tech company in, let's say, Texas, because we have a big bustling tech industry in Texas now, from what I understand, and they're hired by a California company to come to work in California, and they had signed a non-compete with that Texas company, they're protected. They don't have to abide by that non-compete agreement because of California's Senate Bill 699. And that's kind of interesting, kind of an interesting reach by California, right? To, kind of legislate what companies can and cannot do beyond our state borders. And we figured, well, there's going to be some backlash on it. Let's see what happens. Let's see if it stands. Let's wait for the court case to start flying. And then, as typically happens, the federal government kind of followed suit, and they start prohibiting non-compete agreements as well. So again, this is what we more typically see, where California does something, and then after a while, the federal government or other states kind of follow suit. Same thing happened here. The federal government kind of decided that they weren't big fans of non-compete agreements either. And this is something we typically see, depending on who's in office, right? Sometimes we have one party, they're a lot more friendly towards business owners, businesses, that sort of thing. And then you have the other party that is a little more friendly towards labor, towards employees. And that's kind of which way the pendulum swung right now. So that's why we see this move against non-competes. Could it swing the other way if another party comes into power? Possibly, but for the time being, just keep in mind, non-competes are not enforceable in California, even if the employee was employed by an out-of-state employer. So you may be asking yourself, well, if we can't do non-competes, then what what can we do to protect our company? What are we permitted to use to protect ourselves? I mean, non-competes were pretty common back in the day. So you're telling me I can't do that anymore? I'm an organization that's cutting edge. We do a lot of, development. We develop new technologies, new things. What can we do? Well, good news is you do still have some options. You could still have a confidentiality agreement, that where you're protecting, your inventions, your processes, your procedures, that sort of thing. Agreements regarding trade secrets are still allowed. Same thing with intellectual properties. And you can still have non-disclosure agreements. Now, non-solicitation provisions are typically now unenforceable. So in other words, if you have one of your former employee that goes off and decides they're going to start their own business that competes with you and starts hiring or soliciting your current employees or soliciting current customers, um, you know, that is typically protected. There are some exceptions, though. The courts did make some exceptions. They said, if the employee has used confidential customer list, if they stole some customer lists for you or took them with them before they left or made copies of things, plans, trade secrets, whatever, then you do have some legal recourse in that instance. So, it's not necessarily a free for all, but at the same time, it's there are still some protections you can use basically. So again, once you got our agreement or our advice is when you're talking about confidentiality agreements, trade secrets, any kind of these contract sort of things, contact legal counsel. Talk to your legal counsel. Don't just use a one size fits all. Don't just use an agreement that you used for a company you worked for 5 years ago, because these agreements are basically need to be crafted specifically with your company in mind, with what you're doing at this time, with what the employee is going to be doing. So each one of those needs to be tailored and be very specific. So make sure you work with legal counsel if you're considering confidentiality agreements, non-disclosure agreements, that sort of thing, just to make sure they protect you to the maximum extent. All right, moving on. Another development we had is the EEOC's change in harassment guidance. And this one is a quarter century in the making, if you will. So it's been almost 25 years since it was last changed. And basically, EEOC gave us 77 new examples and clarifications on harassment guidance. So, and this won't be news for you or shouldn't be, you know, severely shocking for you if you've done California harassment prevention training recently. Some of the things that are now protected under the EEOC's guidance is Intrusive questions. Harassment can include intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts. Again, best advice for that: tell employees to mind their own business, right? Easier said than done. So again, any of those intrusive questions can be considered harassment now. Denying access to bathrooms consistent with gender identity is also considered a form of harassment. So same thing with misgendering employees. If you have an employee who misgenders a coworker, doesn't use their preferred pronouns, or purposely uses, the opposite of their preferred pronouns, that is a form of harassment now under the federal government. And again, harassment can be based on pregnancy, childbirth, or any related conditions. So someone making fun of a pregnant person because, maybe they have to walk a little differently, maybe they have to take extra bathroom breaks or what have you. If someone is harassing, making comments, making fun, that is also seen as harassment now. And of course, it can occur in remote work environments. And those of you that have been in this remote world for a bit, especially ever since COVID and everything, know that that's definitely a possibility, right? Sometimes, when we're sending emails or instant messages or whatever, we tend to say things that maybe we wouldn't say in person. I don't know what it is about, letting those emails fly or text messages or whatever it is, when you're not in person, maybe we just feel a little more, you know, a lot of those walls come down, if you will, those restrictions. So we tend to maybe be a little bit more disrespectful or say things that we wouldn't say in person. So again, harassment can occur in remote environments, and that was clarified by the EEOC as well. So puts a little more emphasis on making sure that we have, you know, consistent harassment prevention training and that all your employees understand what it means. So again, if you have a remote work environment, keep an eye on things like those messages that go back and forth, group chats, any kind of images or jokes that are shared online, memes, that sort of thing. All of those can fall under this guidance and qualify as harassment. So be very, very careful with that. Now let's talk about artificial intelligence, or AI. Something that's been all over the place in the last year or so. If any of you are from our generation, you may remember the old movie The Terminator about AI taking over or whatever. We're not quite there, but there are some instances where it has gotten companies in trouble. So, and this is a case where um, there was an organization that was using a AI to basically go through resumes, right? That was Mobley versus Workday. Workday was using an AI program or a system to screen resumes. And what they found out was that this AI was screening out people of certain races and people of certain ages. Was it on purpose? Did whoever programmed it say, hey, I want to discriminate, please weed out any resumes that are from people from this country and from people that are, beyond this age? Probably not, but just the way that it was written, it was having a impact on people in those groups. It was weeding them out, kicking them out, having a disparate impact on them. And, you know, that became an issue, obviously, right? You're discriminating against people, whether it was on purpose or not, it was still discriminating against it. So Civil Rights Department has proposed regulations to increase enforcement and limit employer use on it. So our recommendation to you is, if you're using AI for things like writing policies, for things like screening resumes, be careful. I mean, take an extra look at it. Maybe create a committee, an internal committee, to make sure that, you are complying with the law on these things. And again, if you have staff that is allowed to use artificial intelligence, whether it's for their work, to write articles, write blogs, write policies, whatever it is, have a policy in place, and we do have a sample policy through CEA. Take a look at our HR forms page, see if it's available there for you. That kind of gives you a guideline on, employee guidelines on usage of AI. Because again, in this Mobley versus Workday, we'd like to think that it wasn't done on purpose. They weren't necessarily, purposely sorting out these people of African American ancestry or people beyond 40, but that is just the that was just the effect that it was having, right? It was discriminatory. So be very, very cautious if you're moving in that direction with your processes. Now we come to another one here. This is the right to disconnect bill. And this one is actually, it's not in place. It was kind of kicked around and it was looking to see like it was going to come in, but at the last minute, it was placed in suspense in the suspense file. So it's not going to go in place right now, but keep an eye on this one. We want to make you aware because it is one of those things that, we could be looking at it at year end again. It could be brought back up. And what this right to disconnect bill basically would explain protections for employees when they're off of work, right? Basically, it would make it so employers are unable to contact employees during non-working hours except for scheduling an emergency. So it'd make it, basically illegal for you to call your employees and ask a question. Hey, where'd you leave that where'd you leave the keys to the forklift? Where'd you leave that file that we were working on or what have you? Employers would have the right to ignore communications during not working hours and file complaints with the labor commission if the employer kept trying to contact them. So in other words, if this had come to pass and you called your employee because you had a question, they ignored it, and you called them the next morning and wanted to, write them up or do whatever about it, that would definitely be illegal under this law. So AB 2751, again, it was placed in suspension. It didn't pass, but stay tuned on this one, It could come back to visit us later this year because it was gathering quite a bit of steam before it was placed in suspense. So again, it didn't pass, but it is something that's been kicked around for a bit now, so we more than likely we'll see it in the future in one form or another. So some to-dos for you, some things to keep in mind. Again, I mentioned earlier, train your managers, right? Train your managers when it comes to predictable assessments for pregnancy or lactation accommodations. Let them know what the rights of employees are so they don't get you in trouble. Update your reasonable accommodation policies and employee request forms. Audit your employer agreements. If you have non-competes in there or anything that looks like a non-compete, audit it. Consult legal counsel to make sure that you're fixing them. If you're using AI tools, be careful with them. Take a look at them. Make sure that you are double checking them just to make sure that they are not going rogue on you. And finally, keep your staff up to date with harassment prevention training. So that's always the best, one of the best ways to keep out of trouble, keep your employees up to date on those things. Let's talk about some of these industry specific ones. And we'll start with the first one I think everyone's heard about in one way or another, the minimum wage for fast food employees. And of course, it came to pass April 1st of this year, along with the creation of the Fast Food Council now. And this is one that, again, it's all over the news. It's, oh my gosh, restaurants are closing. No, they're not. Yes, they are. Whatever it is, one way or another, effective April 1st of this year, any employee in a fast food restaurant with limited service and over 60 locations nationally in California, that is in California, has a minimum wage of $20 per hour. Now, again, this is something that applies to both franchisees and licensees, and this is for foods that are sold, you know, already prepared. So foods that are sold to be baked, cooked, or heated at home, and is not for immediate consumption. And for if more than 50% of the gross income comes from selling food or beverage items for immediate consumption, then that would apply to them as well. Um, and again, the definition of a fast food restaurant doesn't depend on the type of food. So things like ice cream parlors, boba tea houses, coffee shops, donut shops, etc., they can fall under this as well. And I guess the biggest effect, and this time we got clarification with DIR on was, you know, Mary talked earlier about how if you have a non-exempt minimum wage, how it affects the exempt minimum wage. Well, same thing happens here. If you increase the non-exempt, the hourly minimum wage, guess what? That exempt salary is going to take a pretty drastic jump as well. So the minimum exempt salary for fast food employees, if they're exempt, is now $83,200 a year. So it kind of makes a case for if you run a fast food franchise making your managers or supervisors hourly, if you will. I mean, otherwise, you're looking at quite the steep hill decline there. Next one we had is for healthcare as well. And this was one that, was supposed to come into effect. It got pushed off a little bit. It got pushed off for a month, but, you know, this one comes into effect on July 1st. And the goal is for healthcare workers to be at the $25 per hour range. Initially, the wages are going to range from $18 to $23 by July 1st of this year with set future increases. And again, exempt employees, since the minimum wage increase, their exempt salary is going to be a little bit higher as well. The threshold's not quite going to be doubled, but they must be paid at least 1.5 times the healthcare minimum wage or 2 times the California minimum wage, whichever is greater. So a little bit of relief there as opposed to the fast food ones. But something else to keep in mind though is, for this healthcare minimum wage, it didn't just apply to doctors and nurses, but also to, technicians, billers, janitors, security guards, anybody that worked in those qualifying facilities. And you're asking yourself, well, what is a qualifying facility? Well, in this case, we are looking at places, um, large employers, hospitals, that sort of thing. And the nice thing of it, if you're not sure if you fall under this or this applies to you, check out that bit.ly included there or consult your legal counsel. That bit.ly will give you a list from the state that shows, which specific locations fall under that. Clinics, however, clinics fall under this as well. Um, Good news is dentist offices and pharmacies are not covered by this unless the pharmacy or dentist office is part of a hospital or a bigger conglomerate, if you will. In that case, then you could, but if you're just a, standalone pharmacy or dentist office, chances are you are not covered by this. But again, consult legal counsel, take a look at that bit.ly to see if it applies to you. So, what's next now? What's next is California employers. Well, first thing to do is make sure that you're paying your employees properly and capturing all hours worked. If they're non-exempt, make sure they're clocking them out. And as Mary reminded us, make sure you're not rounding. Make sure you're in compliance with that workplace violence prevention requirements. Remember, July 1st is the deadline to have the program in place or have the program created, have it in place, and have your employees trained on it. Consider policy and training updates regarding pregnant worker accommodations, harassment prevention, and artificial intelligence use. Pay attention to local ordinances that apply to your businesses because they usually go beyond state protections. And stay tuned to ongoing developments by following our blog. Sign up for it. It's not intrusive. We're not trying to sell you anything. We'll just keep you up to date on these changes. That brings us to the end. Before we go, though, I would like to remind you if you have, if you're interested in any kind of membership beyond what we provide on the hotline, we do have several membership options you could look, ranging from $109 a month all the way up to our ultimate membership, which is really, really great. So take a look at that. We also offer what's called HR Assist. So if you need help, you need an HR person in your office or someone to do the HR work for you because, maybe you're smaller or you're in between people right now, give us a call. We can help with that as well. Anna mentioned we do have a survey for your feedback. We'd love to hear from you, what you liked about this, didn't like about this. If that Eli guy was rambling on too long or what have you, let us know, or let us know what you'd like to hear about in the future. If you have specific topics you'd like us to present, or you would like, your hotline to share, give us, let us know. Snap that QR code and let us know. And finally, for those of you that are here for continuing education, we do have some training codes for you. If you are under HRCI, use 669125. And if you're under SHRM, use 24-EPMVS. And whatever you do, do not forget that dash, or SHRM will not remember for something. Do that, but just that dash or it won't count. Finally, if you have any questions about this presentation or any other HR topic, give us a call on the hotline. We'd love to hear from you. And again, let us know what you thought about the presentation. So with that, I'll hand it over to you, Anna, to take us home for the day.
I mean, you covered pretty much everything, so I think we're good. I really, again, encourage you guys to take that survey. This is where you get to share your feedback. This is where you get to kind of vote for what types of webinars and resources that you want to see more of. So really encourage you to take the minute to help us out with that. Again, Mary just dropped into the chat the number of the hotline that is also included in your PDF. And then I'm just going to make sure that, in case you didn't see it, I'm dropping it one more time. Carmelo, before he, oops. If you scroll up a little bit, it's not copying for me, but it's the link to view the previous webinars and see what they also have coming up. So make sure that you access that and make sure that you take advantage of all the free resources available from Alameda County. So with that, thank you to Carmelo and Javier and their entire team behind the scenes for bringing this together. Thank you all for joining us live today. And thank you, Eli and Mary, for sharing your expertise with us. And we hope to see you on another training soon. Thank you all. Cheers.